Hello, my name's Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. You know, one of the frequent questions clients will ask after they've executed their will or their trust and it's all been properly witnessed, they'll say, well, what should I do with it? Well, that's a great question, and the answer is very important. So, in a nutshell, here's what it is. You should store the original executed will or trust where it can be found easily by your executor after you have died. So, it should be in a place that you trust. There should only be, you can make as many copies of it as you want, but don't have two original signed copies, because that can lead to litigation because there's usually something different between them. Then you're asking the court, well, which one is the one I should pay attention to? So please, only one original signed will or trust should be kept by you, and it should be stored where it's safe. Now, the practical reality is that many people choose to store their executed will or trust in their homes along with some other important documents they have. That may not be a good idea because if you have a fire, your will just disappeared. So if you're going to keep it in your home, I suggest that you purchase a fireproof safe. You bolt that safe securely to the floor or to a frame member in your wall, and you put your will and trust in there, along with other important valuables that you'd hate to lose if the place burned or you were broken into and some thief grabbed it and ran out the front door. A second alternative is to store your will and trust in a safety deposit box at your local bank or your local financial institution or credit union. But if you do that, make sure you inform the executor that you've named where that box is located, and you and that executor need to go in and sign the appropriate documents that the lending institution will have for you, which will allow the bank to allow the executor to open your safety deposit box and recover their will or trust. It probably goes without saying, you probably ought to tell the trustee or the executor, where's the key? Where do you keep the key? In addition, you might wish to make an extra copy of your executed will or trust and give a copy to your trustee or executor, and perhaps even to the beneficiaries. So there's no nasty surprises that you disinherited me, your most important son. That can be settled while you're alive, but after you've passed on, that tends to lead to court battles. So giving a copy out so everybody that's going to inherit understands it and has an opportunity to convince you that that's a great plan or it isn't. But the utmost caution I can give you, this is critically important. Never have more than one original executed will or trust should exist at the same time. Multiple copies are okay and might even be helpful, because if you had a will or trust in your home and you gave copies to other people to keep, not all five heirs are going to have their houses burned down where your original disappeared in the fire. So if the original cannot be found and it can be demonstrated there's a reason, a very good reason why it can't be found, it no longer exists, the court can use a copy. But keeping the original is your safest bet. What I'm encouraging you to do is to avoid the Howard Hughes intestate debacle that happened, and some of you will remember Howard Hughes was an extremely wealthy aviationist that owned Hughes Aircraft. Had more money. When he died, he was estimated to have $2.4 billion. In today's dollars, it would be over $15 billion. But when they went to look for his will, they never found one. What happens if you die without a will? Well, then they used the statute, and a court ruled he died intestate. In other words, no will. All of a sudden, all these proposed original wills began to pop up all over. They were all forgeries, ultimately determined by the courts. But, oh, I was one of his relatives, or I was this, or oh, this is the one he gave me a copy of. Don't do that. And if you have 6 people that are going to take in your estate, if each one has a copy of the same one, it's pretty hard to say, well, Your Honor, here's 5 of us that got this, and he shows up with this. That helps the court determine what they should pay attention to. So the best guess is only keep one original copy that you executed. Keep it in a safe place, in a safe, fireproof safe in your home, or in a bank, or locked up in your attorney's vault, and give copies at least to the executors. They know how to proceed. But if you want to avoid some of the family disputes, you might as well let them know what you're going to do, so if they don't like it, they can deal with it with you while you're still alive. Okay, well, I hope that information is helpful to you. Taking the time to have a will or a trust developed and put in place is well worth your time, and it's well worth the minimal amount of money that it takes to get those documents as compared what your estate's going to spend to defend against all these forgeries that may show up. Hope that information's helpful to you, and I hope you're having a great day. Talk to you later.